Okay, everyone, I think we're going to get started. So my name is Andrea Johnson. I'm an associate professor here at New York Law School. And I am neither a constitutional scholar nor a historian. So I'm especially grateful to Penny Andrews for inviting me today to be part of this. And I also want to thank our panel members for being here today. So on my left, we have Henry Ishitani, who is a fellow at Tulsa College of Law. And we have Gaurav Mukherjee, who is a visiting assistant professor of law and the Stuart F. Smith Teaching Fellow at the University of Connecticut School of Law. And Heinz Klug, who is the John and Rylla Bosshard Professor of Law at the University of Wisconsin School of Law. So each of you will have 15 minutes to make your comments, and I will do my best to keep time, and then we'll have some questions at the end. So I welcome you to begin in any order you choose.
Yes, that's easy enough. Hi, everyone. As Andrea said, I'm a legal historian, especially of Reconstruction's rebel disqualifications. I'm writing a history dissertation on that, and I'll be commenting on the centrality of the 14th Amendment's third section to the constitutional politics of federalism in Reconstruction. So Section 3 disqualified former state and federal office holders who rebelled against the Constitution, disqualified them from returning to state or federal office without congressional permission. Basically, it disqualifies the rebel political elite from holding state or federal office until allowed back in. So I really want to be pressing Mark on the special political role I think it played in 1866, especially in comparison to Section 2, which I think Mark does very correctly identify as the most significant and important substantive reform intended by the framers. But before I do, I just want to give thanks to everyone, especially to Andrea for introducing us, and to Penny for putting this on, and to Mark for writing such a phenomenal book, Chance to Comment, along with such great academics. If anything, I think I really run the risk of agreeing too much with your mentors, agreeing so much with Mark in his central idea here, his core message. You know, in his intro, he puts it really admirably clear terms. The 14th Amendment that proponents of congressional Reconstruction framed was designed to prevent rebel rule in the nation and in the former Confederate states. It might be my roots in the constitutional history of the founding, but I find this turn very persuasive. You know, the framers did not trust the parchment barriers, and I don't think the Reconstruction framers did either. At the end of the day, I think Mark shows an overwhelming evidence. We could discuss, you know, as historians, the inside baseball kind of discussions over the Congressional Globe or sourcing and stuff, but it's hard to deny the overall thrust of the evidence that the overwhelming priority is preventing rebel rule. Rebel rule is responsible for leading to violence, insurrection, harassment against Unionists in the South. This is shown in all these key reports, the Joint Committee report, the New Orleans Massacre report. Rebel rule intends to win the war through ballots instead of bullets, especially given that Black people do not yet have the vote, but are now giving 5/5 of their representation to the Southern political leaders. It is corrective. Mark's message is so corrective, especially to the legal academy, confusing Section 1 for the whole the amendment. So count me in. But again, I wonder about the specific parts of Mark's core statement. The 14th Amendment was designed to prevent rebel rule in the nation and in the former Confederate states. Simply put, which was it? Was the design intended simply to insulate the nation from rebel rule? Or was it actually to challenge and prevent it in the former Confederate states? How far does this go? Would preventing in the nation be enough, or did politics within the Southern states themselves have to fundamentally change, and how could this be done? I think on this, you know, John Bingham and Robert Fessenden, the moderate Republicans, have a very different view than Thaddeus Stevens, Charles Sumner, or my personal undervalued icon, Samuel Shellenbarger. that this is probably the most enduring split among the Reconstruction framers throughout the rest of Reconstruction. How far are we going to actually change the terms of state politics? How far can we succeed in that? Mark nods at this issue in places. He says, debates over whether the Republican commitment to federalism doomed Reconstruction are for history journals and university presses, not for law reviews, which might be a bit of a dire warning for my job market prospects, but we're doing our best. But federalism mainly seems to arise around the edges of this particular volume's big idea. Even as we know that for many Republicans, especially the pivotal moderates, they're really struggling with a modified form of Mark's question. How do we prevent rebel rule within the states as well as the nation while preserving federalism? Sandy's points, what are the conservative things that limit a fundamental change, a real second founding? And federalism is possibly the strongest one. Okay, so what were the different available possibilities for preventing rebel rule within the states in the long run? You could do economic confiscation, 40 acres and a mule. This is the focus of many historians, but it was unfortunately dead on arrival politically, especially following Andrew Johnson's pardons. Likewise, with actual criminal prosecutions and punishments. Once Johnson has pardoned people, it becomes incredibly difficult. And I will note in passing, I've made some comments about how most Republicans deny that things like Section 3 are actually punitive. They deny this, what becomes a lost cause idea that this is a bill of attainder, the Reconstruction Acts and the 14th Amendment are a punishment against the South. And we need to, and they take this and make it a core part of their message in the long lost cause. The third option would be long-term federal occupation while keeping the South out as territories and conquered provinces. Unfortunately, that's also anathema politically to most Republicans. So I think that leaves two options imaginable in 1866 in terms of trying to prevent rebel rule within the states themselves. First, you can enhance Republican power in Congress and the power of Congress itself so that it can continue to intervene subsequent to once the rebel states are readmitted and you have the 14th Amendment. Or second, you can shift the political power within the states themselves. Okay, this first one, enhancement of Republican power in Congress. You have a long-term shift in national power from the North to the South and from the states to Congress, where it can arguably then react and respond to rebel power within the states. This is where I see both Section 2 and the original version of Section 3 fitting in. So what does Section 2 do? It gives this offer to the South. You can give Black suffrage, or you can lose national proportion representation, about 40 seats in Congress. Section 3, the original version, it says all rebels will be disfranchised from federal elections, only federal elections, until July 4th, 1870. Both of these are doubling down on the same idea of shielding national power, I think. Section 2 is seen by Mark as the core of the amendment's substantive reform, and I really do agree with that. You're dealing with the end of the 3/5 compromise. The Southern leaders were going to get this massive increase in their political power in Congress. But I don't think it actually empowers loyalists or Black people in the states because 100 times out of 100, the Southern political leadership are going to turn down the Section 2 deal and just say, no, we're just not going to have Black suffrage. We're going to take a loss of national representation, but we're not going to change the fundamental terms of home rule, is what I suspect. The original Section 3, also doubling down on national power in this way. So was the theory then for preventing rule in the states about strengthening the long-term control and power of Congress and the nation? Well, then you're running into the problems of the constraints, the real fundamental conservatism that they had about federalism. Are we really going to, partisan supremacy, Mark highlights, is what could solve this problem. Congress will just determine what is constitutional, what is permissible under federalism. We are going to make changes later. But partisan supremacy is only as good as the cohesion of your majority. What a lot of historians have shown is that the members remain deeply committed to federalism. We're not going to be changed. We don't want a permanent increase in congressional power to be doing direct interventions in the South. To them, this moment of enhanced federal power is just it's just a moment, a post-Civil War moment Once they ratify the 14th Amendment, Congress is going to lose a lot of its power. In particular, we can't force them, once they're readmitted, to do Black suffrage. Not because we think the court or the president will stand up to us, but because that's the internal views of a majority of the party, outside of diehard radicals like Thaddeus Stevens, Charles Sumner. Okay, the second point of view, the second option is shifting of political power within the states themselves. Economic confiscation is impossible politically, but what about a kind of political confiscation? Through the disqualification of leading rebels from exercising power within the states, and hopefully in the long term, shifting to Black suffrage. There's no constitution, we avoid with this a lot of the policy and political problems that come up with Section 3.1, the federal disfranchisement version. It's only supposed to last through 1870. What happens if they just run out the clock on that? How are you going to federally enforce this? Are you going to send federal registrars into all the states to prevent rebels from being in the elections? Isn't this only going to affect House elections? The presidential election is, of course, determined by the state legislators. It's determined by, same with the Senate. They're choosing who is going to be in the Senate. So there are all these problems with this kind of federal electoral disfranchisement. And most importantly, perhaps, one further thing, doesn't the arbitrary dating of this, why are they only disqualified through July 4th, 1870? Aren't you just trying to fix the presidential election in 1868? That's the accusations that are going around. And doesn't the breadth of this affect all rebels? They're all equally responsible for the Civil War, for secession. Doesn't that just put all the white people in the South in the same basket, effectively? So instead, this reflects basically an essential point of uncertainty in the party around which they ultimately had to design the amendment. How endemic was disloyalty, in fact, to the South? They don't agree with President Johnson, the Democrats, in thinking that the rebel masses had simply been coerced into the rebel armies and were actually now, everyone's loyal in the South. As Mark contends, Republicans fervently believed that disloyalty in the United States was endemic in 1866 as it was in 1861. But was this merely the result of elite manipulation? Could the slave power elites themselves be discredited and disqualified from power? Could you drive a political wedge between the common people, the white common people, and the political elite, the slave power that led them into the secession? Or were the Southern masses themselves unable to be relied upon? And therefore, we should have gone with what Thaddeus Stevens wanted. And he said, disqualify every one of them from federal voting till 1870, not 1870, just permanently. It was on this core question that I think the framers set the final form of Section 3. This section pinned responsibility on the rebel elite, on those who held office before the war and betrayed their oaths to the national constitution in order to lead it into rebellion. And they made it in regard to rebel rule in the states as well as in the nation. This, I think, was the core political offer and test given to the Southern public with the amendment. If loyalty actually existed in large numbers among white non-elites, especially in places like Arkansas and Tennessee and North Carolina, the rural mountain places where you have strong pockets of unionists, then you will agree to disavow the state leadership that got you into this situation. You will accept this minimum level of adjustment to the terms of your state politics. So just to the very worst rebels. As modest as this might seem, though, this was the only actual direct challenge to the home rule of the slave power elite in the institutions that they truly prioritized, the states. This was the political wedge. This was the key burden of proof, as the Joint Committee of Reconstruction puts it, that from the fact that there exists, if you pass this, if you ratify the 14th Amendment and you ratify this third section, you are showing that there's a sufficient loyalty for you to come back and we can work together in accomplishing Reconstruction. I think electorally, this was a pretty clever design. Who in the North is going to object to the idea of Southerners having to accept that the Confederate vice president, who's now being put forward as a US senator, and the US vice president who became the Confederate Secretary of War should not be holding power? So when they don't, the South refuses the deal. And 33 out of roughly 1,200 Southern legislators vote against the 14th Amendment. It is across the board denial by the political leadership. All focus on this, and they all focus on this provision. They all focus on this offense to Southern chivalry. It shows just how in charge the old power, the slave power, remains in those states. And for me, the effectiveness of the 14th Amendment's design ends up being, as a matter of constitutional political design, ends up how then that justifies this much more aggressive intervention into federalism to try and root out rebel power. This is where the real political revolution against rebel rule happens. From this cautious, compromised means of directly securing limits to rebel rule in the state, in the 14th Amendment, it transforms into political purpose is a justification for actively intervening into the states with the Reconstruction Acts. Without Section 3 in this form, I posit, Reconstruction would have likely stayed limited to insulating the North, not intervening in the South. And because of that, it justified the real revolution that Foner does identify in terms of Black politics, Black office holding, and an attempt to transition the South to an actual manhood democracy.
So hi, everyone. Tough act to follow. So my name is Gaurav Mukherjee. I'm a comparative constitutional theorist at the University of Connecticut, and thank you for being here. And I just want to thank Penny Andrews and, of course, Mark for sharing this wonderful book with us. Mark and I know each other for quite a few years, and his generosity of spirit has been an incredible influence in my life, and he's an absolute role model for me in terms of his generosity of spirit and the kind of collegiality with which he has consistently carried himself through life. So it's genuinely an honor to be here and to discuss Mark's book. And let me start by confessing that this is one of those rare books that make you want to rethink the very premises on which one teaches and writes about Reconstruction. For most of us, the 14th Amendment is the high point of American constitutionalism. Equal protection, due process, birthright citizenship. It's the text that allows us to trace a line from Reconstruction through Brown to Obergefell. It is the quintessential liberal triumphal story. But Graeber tells us that story is a myth. He insists that the real logic of Reconstruction was not rights, but regime survival. Republicans in 1866 did not believe that the Union's victory was secure. They feared, and with good reason, that the Confederates would return to power and that the Civil War would be won on the battlefield but would be lost in Congress. The point is stark. Reconstruction was about punishing treason and rewarding loyalty. Rights were secondary, sometimes symbolic and sometimes instrumental, which is a deeply unsettling framing. It cuts against the grain of how con law is taught and remembered. But I want to suggest that Graeber's reframing, unsettling as it is also clarifying and not just about the United States in the 1860s. It resonates with how constitutions work across time and space. And what I want to do in these remarks is to engage with Mark's account, enrich it with more of the American history that his thesis brings into view, and then test it against two comparative examples: India after 1950 and Brazil after 1988. Together, I think they show us that the stakes of Graeber's argument that rights without structural safeguards are fragile, and that militant democracy, however uncomfortable, may be the only way to preserve constitutional orders in moments of deep rupture. Now, let me begin with Mark's core claim. The conventional narrative tells us that Section 1 of the 14th Amendment, with its guarantees of due process and equal protection, was the centerpiece of Reconstruction. Graeber flips that on his head. He argues that the real action was in Sections 2, 3, and 4, where Section 2 cuts congressional representation for states that disenfranchise Black men. Section 3 bars ex-Confederate leaders from holding public office, and Section 4 repudiates Confederate debts. These provisions are designed to ensure that disloyal actors could not walk back into Congress and undo the war's gains. Section 1, by contrast, was more telling, more symbolic. It promised rights, but it was not the provision Republicans cared about most in 1866. This is a jarring shift because it tells us that Reconstruction was more than the liberal promise of equality, and it was about partisan entrenchment. It was about ensuring the Republican coalition could survive in the face of a resurgent white South. Now, many of us are instinctively resistant to what seems like a deflationary account. After all, we live in the world that Section 1 built. Equal protection and due process have become the lifeblood of constitutional litigation. But Graeber's point is historical. In the immediate aftermath of the war, what mattered most was exclusion. Section 3's loyalty test was not just a footnote, but it was the core of regime survival. But once you see Reconstruction through its lens, its trajectory looks very different. The framers of the 14th Amendment were, in effect, implementing and experimenting with forms of militant democracy. They were embedding into the Constitution the principle that not everyone gets to participate, that some actors, by virtue of their disloyalty, are excluded from the political game. But then the story begins to unravel. Within a few years, the very mechanisms designed to prevent Reconstruction are dismantled. Now, take the Amnesty Act of 1872. Section 3 disqualification should have barred thousands of ex-Confederates from office. Instead, Congress granted sweeping amnesty. Jefferson Davis never returned to the Senate, but countless others did. By the mid-1870s, the old Confederate elite were back in charge of Southern legislatures. Now, let's look at courts. In the slaughterhouse cases of 1873, the Supreme Court read the Privileges and Immunities Clause out of the Constitution. In the civil rights cases of 1883, it gutted Congress's enforcement power under the 14th Amendment, striking down the Civil Rights Act of 1875, thus making equal protection largely toothless. Let's now talk about federal enforcement. What does the Ku Klux Klan Act of 1871 do? It gives the federal government power to prosecute racial terror. But within a decade, the Justice Department abandons the field. By 1877, the compromise ending Reconstruction, the experiment in militant democracy appears to be over. The results were fairly catastrophic. Jim Crow is hardly an accident when looked at in this light. It was the direct consequence of abandoning the loyalty framework that Graeber highlights. And the lesson that we take from this is sobering, that without structural exclusion, rights prove to be fairly fragile. Now, let me turn a bit outwards, because one of the great strengths of Graeber's book is that it pushes us to think beyond the American case. What does it mean to punish treason and reward loyalty? How do constitutions balance rights and regime survival in moments of rupture? Now, I want to make a slightly provocative claim. Now, I want to compare this to India in 1950. On the surface, the Indian Constitution looks like the opposite of Graeber's story. It's a breathtaking charter of rights, equality, free speech, freedom of religion, federalism, secularism. But look beneath the surface and the story looks slightly different. The Constitution preserves much of the authoritarian scaffolding of the British colonial state. It retains preventive detention. It entrenches emergency powers in Article 352. It gives governors powers to dismiss subnational governments, and it builds and retains a highly centralized executive. Crucially, there is no reckoning with those who had fueled communal violence during partition. No disqualification of Hindu nationalist agitators or Muslim fundamentalist agitators, no purge of collaborators with the British Raj. The emphasis here is on principle and not exclusion. And the consequences are immediate. In 1950 itself, the parliament passes the Preventive Detention Act. In 1975, Indira Gandhi declares the emergency, suspends civil liberties, jails political opponents for 2 years, all within the framework of the Constitution. Now let's fast forward to today. Under Narendra Modi, India has undergone or is undergoing what Stronach would call a regime change moment. Modi has centralized executive power, stripped Kashmir of autonomy, and used the Citizenship Amendment Act to openly discriminate in the process of naturalization. He has disqualified opposition leaders like Rahul Gandhi through selective prosecution, and courts have often acquiesced. What we're seeing is not just democratic backsliding, but the consolidation of a Hindu majoritarian regime. And here, Graeber's framework is illuminating. India in 1950 enshrined principle but left power intact. It refused to build militant safeguards, and after many years later, those very actors, Hindu nationalists who were peripheral in 1950, are remaking the state in their image. It is Reconstruction's tragedy in another key, that rights without restructuring, without thinking about what Roberto Gagurea has called the engine room of the Constitution, proved to be fairly brittle. And a regime bent on exclusion now uses the Constitution itself to entrench power. Contrast this with Brazil in 1988. After nearly 2 decades of military dictatorship, Brazil's framers understood that rights alone were not enough. They had lived through authoritarianism. They knew it would return unless the Constitution itself built defenses. So they embedded militant democracy in parts of their constitutional design. 3 choices matter, and I want to highlight. The first is electoral justice. Brazil created a parallel judiciary to oversee parts of its electoral process, culminating in the Superior Electoral Court, and which was much more than just about counting votes. The TSE, as it's called, polices campaigns, regulates the use of media, combats disinformation, and certifies results. It is constitutionally empowered to disqualify candidates who abuse power. Second, prosecutorial independence. The Ministerio Público was made constitutionally autonomous and tasked with defending the democratic regime. It is not subordinate to the executive. Third, social rights tied to national systems. Health, education, and social assistance were made judicially enforceable, not as empty promises, but tied to bureaucratic infrastructures like the unified health system, creating both administrative capacity and social constituencies invested in democracy. Now, this mattered when Jair Bolsonaro sought to delegitimize elections. In June 2023, the TSE bars him from running for office until 2030, citing abuse of political power. The ruling was not just judicial activism, it was constitutional design functioning just as intended, anticipating authoritarian relapse and neutralizing it. Brazil, in other words, succeeded where the US and India has failed. It has rewired power to make rights durable. It has punished treason and rewarded loyalty, not just as ad hoc politics, but as constitutional architecture. Taken together, I think these comparisons sharpen Graeber's point. The United States, in 1866, briefly embraced militant democracy through Section 3 disqualification and the Enforcement Acts, but it abandoned them in the name of reconciliation, and rights without exclusion proved too weak to resist the forces of white supremacy. India in 1950 enshrined rights but preserved the architecture of colonial power. It refused to reckon with disloyal actors. Now, I'm not sure about what lessons for constitutional design we can take when it comes to something like a Hindu disloyalist, but happy to talk about it more in Q&A. Now, today, Modi's regime uses these preserved powers to refashion the state. Brazil in 1988 did the opposite. It rewired institutions to defend democracy against authoritarian relapse, and when Bolsonaro is testing the system, it appears to be working. The lesson is pretty clear. Rights without structure are brittle. Constitutions that fail to punish treason cannot preserve liberty. Now, this brings us home once more. Are we in the midst of a reconstructive moment? Now, the political order forged in the mid-20th century, the New Deal plus civil rights consensus, is looking like it's about to unravel. Donald Trump's presidency reveals how vulnerable our institutions are to disloyal actors, and January 6th is not an aberration. It was a stress test, and the system nearly failed. Now, Graeber's work forces us to ask, will we repeat Reconstruction's mistakes? Will we place our faith in parchments, promises of equality, while dismantling the structures that keep disloyal actors out of power? Or will we find ways, like Brazil, to embed militant democracy into our constitutional fabric and seek to so clearly that those who seek to destroy democracy cannot be trusted to govern within it? Graeber leaves us with questions more unsettling than his answers. So who is the Constitution for? Who does it protect? And just importantly, who does it exclude? In 1866, the answer was unambiguous. It was for the loyal against the disloyal. We may find that illiberal, but perhaps the greater danger is to pretend that principle alone will save us. Because if we learn anything from Reconstruction and from India and from Brazil in the comparative examples that I just talked about, it's that constitutions without militant safeguards may be built on sand. Thank you.
Thank you very much. I would first of all thank Penny for the invitation, and just want to say how much Mark has taught me over the years and his confederates over the years about US constitutions and constitutionalism, and how much I've appreciated that. And also his willingness to engage. He helped us bring the schmooze to Wisconsin, and just, he's a mensch, right? Fantastic to have him. I was really taken when reading the book about this relationship between, the title, Punishing Treason, Rewarding Loyalty, and the process of reconciliation. And it came through to me particularly strongly in that distinction, which the book talks about, doesn't focus on as much, and I'm hoping that future volumes will draw more on, between what you talk about as congressional reconstruction and presidential reconstruction. And I was astounded to see how those are actually simultaneous, right? While the 39th Congress is sitting and doing this the constitutional reconstruction, at exactly the same moment, President Andrew Johnson is engaging in presidential reconstruction, which is in a way completely counter to what's going on in Congress. And it's that tension which I thought was fascinating. And focusing on that, I started being interested in what is the consequences of failing to truly punish treason. And it brings me back around, it brings us around, I think, to last night's conversation as well. Because if reconciliation is the focus, what are the implications for that in terms of both the constitutional reconstruction and that relationship between transitional justice and constitutional transformation? Because if indeed Congress is in this process of trying to reconstruct the nation constitutionally and integrate the nation again, how does that engage with the fact that the possibility of a constitutional transformation is disappearing every day that they're working, right? Because of the pardons, because of the re-empowerment of the slave power that's going on simultaneously with their efforts. So one way I began to think about this is, if you go back to the fact that the Emancipation Declaration is in 1863, and at the same time, Lincoln's 10% plan is also presented. And this is in the midst of the war. And it makes me think about our own experiences in Southern Africa, where the African National Congress, in the midst of the war, is proposing a constitutional set of principles in 1988. And what is this about? Well, what I think the Emancipation Declaration was about from Lincoln's perspective, and I could be wrong, and also the 10% plan, was to undermine the military efforts of the South. Right? This was an attempt to win the war, just like in 1988, partly what the ANC was doing with its constitutional principles was to undermine the legitimacy of the existing apartheid regime in the West and to pursue the war and end apartheid. So there is the consequence. So this use of offers of what will be if the power shifts the other way is a way to undermine the existing military process, right? The violence that's going on, to try and bring it to an end in one's favor. It also sets up a certain path dependency. And what I find fascinating is when you go from Lincoln's use of reconciliation, if you like, emancipation and the 10% plan, through to Johnson, reconciliation suddenly becomes the dominant form, whether it's through pardons. I mean, and I was astounded to learn about the amount of the pardons that were going on. Johnson was handing them out like candy, right? And this was to that elite group, not just to the pardoning of the common soldier. This was to the elite and those in power that were getting these pardons. And as a result, they were getting their property back. So the economic and political effect of what was going on in presidential Reconstruction was to, in fact, re-empower the Southern elites at exactly the same moment that the Congress was writing the 14th Amendment. So I just find that really an interesting tension, and found that, in fact, we were doing the same. In the South African context, the whole process of truth and reconciliation, if you run through that process over time, even though Mandela rejected de Klerk's blanket amnesty, which de Klerk had signed and left on the desk for Mandela when Mandela walked into his office, Mandela said that was not their agreement and put it aside. The actual process of the TRC was one that effectively guaranteed amnesty, even when they didn't tell the truth, even when they didn't actually reveal what was going on. They'd never pointed to their political superiors who were actually responsible. Right? But were given amnesty anyway, because reconciliation was more important at that moment. So when this process of if reconciliation was for the purpose of maintaining the unity of the country, in the case of the United States, or reconciliation was the purpose of ensuring that we wouldn't have capital flight, etc., from South Africa in the 1990s, the effect is a path dependency and undermines the possibility of real constitutional transformation down the road, whether it was the real societal transformation of the South or whether it was actually the transformation of South African society to a genuinely non-racial society. So that tension I thought was absolutely fascinating as I read the book. Other point, so then going back to that question of punishing treason, what is the possibilities that if we were serious, Sandy raises the point of there may come a time when violence matters. As somebody who was prepared to and did take up arms against apartheid, yes, there's those choices that are very hard and they have consequences which can be quite devastating too, to make those choices. But what is the possibility that if in fact in this transition in the South, there had been examples made of even that 0.1% senior leadership, if they'd actually faced treason trials, and at the time the consequences of treason would have been probably the death penalty, if they'd actually faced those consequences, what message would that have sent to those below them? Because once they are reconciled, yes, they lose some political advantage for a while, they can't participate, but most of their community can. There's no real concern about what the consequences of treason would be. So I was fascinated with the goal is to punish treason, and maybe, as was pointed out, that maybe the structural ways you could do it for protecting militant democracy, etc., maybe constitutionally ways to do it. But I'm interested in what the impact of that failure to actually hold people at some elite level, some leadership level, for the consequence of treason actually means for Reconstruction generally. And that's where what I see all over is denial. F.W. de Klerk, in the period after he left government and was a private citizen, still spent his time touring the world telling whoever would listen that apartheid was not a crime against humanity. it was an unfortunate policy that just didn't work out right. It was complete denial. And only after he died did his foundation release a posthumous video where he said he was very sorry for apartheid. But it was that level of denial that allows today white South Africans to basically say there was no consequences, that you shouldn't touch their lifestyle in any way. Wealth tax is off the table. I mean, you shouldn't consider any of the consequences of the benefits that you received as a result of apartheid. And in fact, today, white South Africans are victims that are invited to the United States by the President of the United States. That's the power, I see, of denial. That we're not prepared to acknowledge that apartheid was a crime against humanity, or that treason in the Civil War was really treason. That gets put aside, that power of denial. And the one, only for the last minute I have, the only positive version of that, if you see that what I see is that if you acknowledge the crimes committed, whether treason in the rebel states that produced the Civil War, or the perpetration of the crime against humanity that was apartheid, or the insurrection and attempt to overturn the US election with the storming of the Capitol on January 6th, it makes it more difficult to engage in the levels of denial that have followed these historical events. In comparison, the acknowledgement of the Holocaust and the education and even legal prohibition on denial in post-war Germany may not have prevented genocide from reoccurring in other parts of the world, but it's made the claim of genocide, when upheld by the presentation of evidence, a powerful stigma that does not limit the capacity to deny. Right? That limits the capacity to deny. So if you're able to acknowledge that treason really is treason, that it's something that is unacceptable, then the ability to deny that and to have the myth of the lost cause might have been much harder to sustain. And I feel that that moment is really important. Thank you.
Thank you. So we will take questions now or comments. Sandy?
Another gauntlet. As a lawyer, it seems to me the issue of treason is subject to discussion. That Cynthia Nicoletti wrote a really terrific book on why Jefferson Davis never was, in fact, tried. And one of the reasons is that very good lawyers doubted that he was guilty of treason, either on the completely technical ground of finding two witnesses to the same overt act, but also the whole question of the constitutionality of secession. And I disagree very strongly with my friend and co-editor, Akhil Lamar. I think the US Constitution, correctly understood, is in fact silent about secession, and that the Southern arguments as abstract arguments of constitutional theory are no worse than Abraham Lincoln's argument as to, the perpetuity of union. So, frankly, the reason I might disagree with Mark and supports the death of 700,000 people between 1861 and 65 is to eradicate slavery. But there's no serious argument that slavery was unconstitutional unless you're Lysander Spooner. But he is or is not serious depending on what you mean by mainstream. But it does seem to me that the argument about treason does beg a legal question in a way that the argument against slavery doesn't, because it's a genuinely moral question. And so going back to the clerk, that, apartheid was worth rebelling against, whether or not it was legal.
Oh, absolutely. But when they took up arms against the Union, wasn't that treason?
Not if you believe there's a right to secede.
Sandy, the question is, do you have a right to secede peacefully
Yeah.
as opposed to by arms?
Once you take up arms, you're committing treason against the.
Well, then we get into the higher. It's a decide, okay. Lincoln successfully provoked the graduates of the Citadel to make a disastrously stupid decision to fire on Fort Sumter. But it does take two to have a civil war. And Lincoln was very clear that he was not going to tolerate peaceful secession.
Other questions? Yes.
I'm a proceduralist, so I'm always interested in the proper forum for issues. And would you bring up the reaction of the world really to World War II, and then the Nuremberg trials made a difference, right? And I wonder if part of the problem is that when you talk about treason, the country, which is treased upon, I don't know what the verb form here is, presumes it is a proper forum to hold the treasonous people accountable, but perhaps we should look beyond that in the way that the world courts, held the Nazis accountable. Is that promising or no?
Well, I'll mention briefly, the only people they're able to execute are Andersonville, war crimes, crimes against humanity. So it is a model for that Nuremberg kind of angle. I mean, yeah, the treason question, and it's similar with confiscation, all these constraints of the old Constitution. Why can't we do confiscation? Well, because we could only do it on a theory of contraband during the war, and after the war, there's this corruption of blood thing. And so you can't confiscate for treason because it's supposed to go to their children. You can only take their property at best for the lifetime of the person who was a traitor. And it's like the level of constraints. The other thing with the treason thing is you have to convict them in a jury, a local jury, a jury that's local to the overt act. And you could have a theory that, it's a general thing. They invaded Pennsylvania. And so a Pennsylvania jury should be able to convict Jefferson Davis, but they refuse to do this kind of greater degree of creativity in this way, this constitutional conservatism. Again, as with federalism itself, each of these things keeps them from doing this more ambitious experimentation. But on the other hand, I think we are also highlighting, Gaurav was that the level of experimentation in militant democracy is also really impressive. They do their best to come up with different modes to get around each of the reconciliation policy things that are put in their way by Andrew Johnson, by these others. And so we should also praise them for that, I guess.
If I could just add, there are obviously also limits to constitutional design. I mean, if we look at militant democracy and its most famous practitioner, Germany, I mean, it's not doing very well in terms of, trying to keep out forces that are antithetical to the constitutional structure. So a lot of it has to do with cultural specifics, of course. And you're right, there is this problem of imagination as well. So, yeah.
Professor Simpson?
Oh, sorry.
No, I was just signaling.
Then Professor Simpson, do you?
I had a quick question about, actually, it's probably not a quick question. I had a thought about two aspects of how you all think about implementing, including through structural reforms, militant democracy. So part of what one might think about is, what role does it play whether one thinks that people's minds can be chained versus people's minds will be the same, but there's a middle, let's say 50% of people that can go either way. And so the goal is to have the guidepost at a place where those people are not enticed to go against democracy versus we're going to shift the spectrum so that 100% of people are committed to democracy. what role does that play and what are the implications for the choices that one might make, or let's say the Reconstruction Congress did make? And then the second question was, to what extent is constitutional design that wants to preserve militant democracy or ensure it dependent on identifying the right biggest obstacle? So to the extent that disloyalty, let's say, or rebel rule is the biggest obstacle to overcome in this particular context, white supremacy is sort of secondary. And so part of what you were describing, Gaurav, is that white supremacy comes back in part because that was not the priority in the restructuring. And so that then overcomes the attempt to ensure something else that maybe was thought of as the primary goal. I'm not expressing this very well, but one of the questions that I wanted to get your thoughts on is, to what extent, like, does, for example, India in 1950 have to be right about what the biggest problem is? For example, let's say Hindu nationalism or something like that. And to what extent does it matter that, for example, Brazil identified one kind of problem versus some other kind of problem in how they were structuring that?
Yeah, sure. I mean, I guess, you know, one of the primary reasons why, which is cited, and it's this incredible accident of history, is that Mahatma Gandhi is killed by a Hindu nationalist in 1948. And then thereafter, what happens is that Hindu nationalism is discredited in such a big way in the cultural fabric of the nation that it's imbricated, but it sort of never rises to electoral power up until the late 1970s. So it's this incredible accident of history, which had nothing to do with constitutional design at all. And it's also the case that, you know, each side will argue, right, whichever side of the political spectrum, that the other side is insufficiently committed to democracy. So the left will always argue it's the right, et cetera, right? So maybe this is too postmodern a take on it, but I mean, there is a way in which we can never really disagree on what are these fundamental precepts of democracy, and which is why sort of constitutional law just gives us these structures to keep arguing about it constantly.
On the same line, I mean, this is a fundamental problem in the South with the state constitutions. It's like there's arguments of like, oh, could Southerners have been appeased? Well, there is a 50-year plus history of Southerners not being appeased sufficiently leading up to the Civil War. The 14th Amendment is not sufficiently moderate for them. All these examples in like the fundamental, like the state constitutions try and put in place. Just if you say, give an oath that you just accept the civil and political equality of all men, that's our standard. And that's too high a bar for a sufficient number of people's minds to be changed, or at least it's reacted against with such levels of political violence. And so how do you build up a political order that can keep that violence down and get enough education, get enough material changes, a Marshall Plan for the South, you know, perhaps that was what was needed, enough for a longer term to change the attitudes of a sufficient portion of the citizenry to accept this, because like you're already not at that baseline that you need for the terms of a shared democracy in the South at the beginning. And yeah.
Right. When you talk about identifying the problem as kind of a single problem, it raises for me the issue too of, on the other side, those who are trying to address it, they don't have a single position either. And I think Mark's book is so fantastic in showing us that among the Republicans in Congress talking about the 14th Amendment, they had such a vast range of differences, which means when you come up to really difficult issues, the possibility of addressing them dissipates, right? Your ability to actually take on the really hard issues. So in South Africa, we could have identified from the beginning that the biggest problem was inequality. That we understood, but it was so much easier to say no, of course, because race is the marker of that inequality. Let's deal with race only, right? That's what their constitution fundamentally does. And all the attempts, yes, we put in socioeconomic rights, etc., as attempts to try and address that inequality. But any really hard attempts to address that inequality, we could not overcome because of divisions within the group that was in charge of the change. So unless you find that moment where you get such unity over a particular issue. The Allies after the Second World War, as your point, they had unity that some of these Nazis were going to be dealt with, right? But that still only went to such a thin group at the top, right? The Nuremberg trials, the Frankfurt trials, etc., deal with such a thin layer. And then they abandoned it in the face of the Cold War. But still it had that impact within Germany that was quite transformative in the sense of saying this issue is one that there was a violation here that you all carry responsibility for. It's that move that I think would be most interesting for genuine reconciliation, that there's an acceptance of responsibility that's not just by example on that top group, but everybody else then forced to acknowledge that that was something. And I don't see that in terms of what happens in the South afterwards. There's never that acceptance that this actually was a violation, that this was a problem, whether it was slavery or whether it was the secession, right? And whatever nice legal arguments we can, it's that basic sense of if we're on the back foot, if we actually committed a wrong, then maybe we have to recompense in some way. But if we've never committed a wrong, and I mean, that for me goes to the issue of transitional justice. What's key, and I thought, Ruti's book, the first one, was really about what elements of law needed to change in order to get to justice. And I think the kind of modern version of transitional justice is give them amnesty and we'll all be fine. And I don't see that actually doing the job.
Yes.
Yep. So I wanted to get at these, first of all, by expanding Professor Mukherjee's idea, because one thing that struck me is, at least in my experience and study, regimes that have the discretion to deal with perceived existential opponents is incredibly wide, or much more expansive in most constitutional systems than the United States. So the first cut at this is the Commonwealth, because at least in places where I've done human rights that are Anglophone, a lot of them have emergency law systems which date back to the Defense of the Realm Act of 1916. And I suspect India and Pakistan are both inheritors of that, as well as South Africa. But not just in Commonwealth jurisdictions, so also civil law jurisdictions, so state security courts in Turkey, et cetera. So it's very common. The question is, if one part of the question is constitutions giving regimes this extraordinary power to deal with perceived existential threats, whatever they are, and assuming there's unity to identify what they are, how do you safeguard against that discretion being abused, which is generally speaking the norm? And I think that's another big problem in constitutional design. And perhaps out of the conversation, culture and education is at least as important as constitutional design, historical accident too, maybe more so.
Yeah, I think you can't. It's just, these regimes are held together by norms. And I'll guide you to the example of Turkey, where you had the Rafa Partisi case, which eventually goes up to the European Court of Human Rights, which is a sort of a precursor or a party that's farther to the right of the Law and Justice Party. And that gets banned, I believe, around 2006 or 2007, goes up to the European Court of Human Rights. It asks if this is a violation of associational rights. And they said, no, it's fine. It posed an existential threat. There's a margin of appreciation. But then what that does is that it sort of puts a greater fillip on the part of these forces to come back in a more moderate force in the form of someone like Erdogan. So it's very hard. I don't think that there's only so much that constitutional design can do. And I think that we have norms at the end of the day, and it's hard to police these things. Yeah. Sorry, that's an unsatisfactory answer, but yeah.
Yes, in the back.
So I kind of want to build on that a little bit though, because I'm left feeling kind of fatalistic about this entire process. If what y'all are telling, if Mark's book is telling us there's this bare knuckle politics of Reconstruction, we had these tools to clear out the people who were unfaithful. Henry tells us if we'd only gone further, if we'd only disenfranchised more of them. I hear from Heinz, if only South Africa had the tools to address inequality, but didn't do it. Right? I hear from Gaurav, Brazil has these tools, they use them. In the US, we have these tools, we choose not to use them, right? So at some point, it seems like what I'm getting from all of you is, look, what we need is, this is gonna be a solution from, if we're gonna have a solution, it's going to be from there being a political coalition that is willing to just push harder. And if that's true, I'm wondering why we're considering any of this formal constitution stuff at all. Is it doing anything for us? Or is it just what we need is a political coalition that is more willing to solve the problem? And if that's true, where do we go from there? Like, what do we have to contribute to that conversation other than telling people, our knuckles need to get bloodier and we need to, bludgeon the enemy more harshly into submission?
I guess I'll start with that. I mean, I do think, as much as we're shifting things over to constitutional politics, and that's a really key intervention, constitutional law and how the part it plays within constitutional politics does still matter. And the degree to which you can position, and that's why, I keep returning to is disqualification punishment? If you can convincingly argue that it is not, in that this is a forward-looking security measure that is totally backed by the constitutional traditions of all the states. They stripped voting from Black people. They took voting to a degree from women in the past and put that on security terms. And okay, we're just doing the same thing, except for an actual security problem here. If you can position it effectively that this is, we are accomplishing change through bare-knuckled use of the real legitimate tools, and you can pull people along with you. They don't want to see the Stevens in the Senate, and if you can make those symbolic victories and sustain that long enough, maybe it can work. But it's darn tough when, you get Supreme Court and there's all these contingencies that they start putting a lot more friction in your path. And yeah, it's tough.
I think it is that, why does constitutions matter, right? Because you are trying to embed norms, whether those norms are helped through education and culture, etc. But you're trying to embed norms and trying to sustain them. And, I was saying to Sandy yesterday, if we have a debate about what's the difference between politics and law, or politics and constitutional law, in politics, you just vote. You don't even ask why you voted, you count the votes and they win, right? In law, it turns out they vote as well, right? In the Supreme Court, they vote as well. But when they finish vote, what they normally do for us to accept it as law is they make an argument which they have to share with us in a written form, as it turns out, and we get to argue about whether they got it right or wrong, and the society can have a debate about whether these norms actually matter, etc. At the moment when they issue an opinion and don't give us reasons and say we got to follow it anyway, then maybe it's just politics and not norms. But we want to struggle for that distinction. That it's still important that at the end of the day, they are forced to actually justify and are to that degree accountable. Right? And so that level of accountability is what you want constitutionalism to do, which regular democratic politics only has to a limited degree. Right? Do I win the next election? If that election's actually run genuinely and properly and counted correctly, etc. Right? I mean, all over the world that I work in Africa, that's the first question. Right? Was the election actually fair? Was it actually counted? Was it, and then will we accept it? Right? But as long as you're able to justify and require that kind of level of accountability, then you have constitutional politics and constitutions.
Yes.
So I wouldn't just give up on it.
Kimberly?
Hi, yes. So I really love that answer. My name is Kimberly Cruz. I'm a 1L here, but previously I care about the Constitution because in Queens, the people are not understanding it. There's a dilution of culture and education around the world. And with artificial intelligence, what does that even mean when you can manipulate the perception of our senses, right? At thought, the US Treasury is so vulnerable that the world knows our institutions are that vulnerable. So how is our mind not more extremely vulnerable, more of a toy to play with? So your point on like why the Constitution matters, my generation does not carry their Constitution. Akil Amar tells us, carry your Constitution in your pocket, right? I was 18 years old when I heard that. And so I do that. And sometimes I get my pocket Constitution on the subway, right? Because there are people that have never read the first words. There are people that don't understand what the words actually mean. And we care about it. I'm happy that we're here, but we should fill up these rooms with the law students that have to create barriers, right, for these tools to just keep diluting our education, our culture. So my question really is, how do we embed norms when we're so surveilled as a world population? 100 years ago, we had 2 billion people in the world. Right now, we have 8 billion. We are subatomic particles. We are not, right? We're not supposed to be animalistic. I'm not black or white. I'm a person, right? I'm of all these cultures that came together, and now we're America, right? Whether we want to have a constitutional convention, which I'm so for, like we do need to shake and be the beacon of hope. So I ask, what are some tangible tools, thoughts that we could go back to the public after today, after we hear the speaker, but what can we do to learn and solidify and not feel like we're putting our knuckles together, but actually using what God gave us to use, what our George Washington founding father told us to do, right? Be exceptional, be something else so the rest of the world can see you and follow through like God do.
That's all on you.
Kimberly is one of our fantastic 1Ls here. She's in my contracts class.
Yeah, maybe not put the Constitution in your pocket, because that in a way is, when I think about that, there's lots of people who hold up the Constitution and says, this is what it means, and whether they've read it or not, I have no idea, right? So the Constitution can also just be used as a hammer to say, I get what I want, as opposed to forcing that conversation, which says, well, what exactly might it mean to everybody and to all of us together, right? And that's earlier today, the point was made about building a social movement, right? The only way to address this is to communicate with people, to get people involved, to make people realize that politics and constitutional politics actually matters, as opposed to reification of a 18-page document, which is not even written in understandable English today, right? I mean, it's what way do we actually have that conversation that incorporates more and more people? I have a fun thing with my students where we do a constitution making exercise, a simulation. And the simulation's based on a futuristic post climate change world where the US is no longer the US. It's, Pittsburgh's the only city that survives on the East Coast and goes up through to Montreal, right? And now reconstitute your society. And we have exactly that open kind of conversation about what kind of society you might want to and what it would take to maintain that society. But at least that gets students out of, we're locked into a document that we're fighting about, as opposed to trying to think about the norms that would matter to us in the future.
Yeah, I mean, I think I'll just say two things to that. One is that, we need to decenter the court in terms of how we talk about the Constitution. It's, we engage in constitutional conversations every day. That is just, it suffuses everything that we do. And there are more institutional centers that give meaning to the Constitution than just the courts. Different people vary on what that means, but yeah. And politics is much more local. There are state constitutions, of course, which we are increasingly relying on. So yeah, two things.
I'd say to the extent the extent that we idealize or continue at all to idealize the founding fathers, it's that they believed in enlightenment and experimentation, in progressing and changing and improving and responding to new knowledge. And that's what we should be really taking forward, expanding our constitutional imaginations and doing these kinds of projects in your Con Law 1 class and stuff, where you are to the leaders, major part of the leadership of civil society is going to be the future lawyers like yourself. And you are going to have to be spreading this on to other citizenry. And so just having that consciousness of the possibilities for experimentation, maybe we can actually get to a convention, something with a radical degree of reform that could actually fix, really address things. And that we, it's a difficulty, the perniciousness of originalism or just blatant textualism. I'm reminded I was on a panel in Oklahoma where the gentleman sitting next to me we were talking about the unitary executive theory, and he's like, I see here, it says that the executive power is vested in the president. That's the answer. I'm like, what the heck does that mean? That's, speaking of Latinate, but that is so contested in historically. Nathaniel Donahue in the back could very well speak to that historically, but there's so much more imagination of what that possibly could mean, including in Reconstruction, in trying to police the ability of the president to just choose who he can remove and not, in a different form of government and creation that is possible in that time, and looking to that historical examples for how we can then, it is possible to change things. And we have to do it by decentering the court most of all. But
And just one more little thing is, and it's basically about civics education. And I think of the work that Sandy and his wife have done in terms of putting out a much more civic education way of understanding, right, which we've failed so badly around the country on.
Right.
That's great.
I think we're out of time. So thank you to everyone for your questions. Thank you to our panelists for all your wonderful comments.